This is Bloomberg Law with June Grasso from Bloomberg Radio.
The U.S. Supreme Court is poised to allow abortions in medical emergencies in Idaho, according to a copy of the opinion that was briefly posted on the court's website and obtained by Bloomberg Law exclusively. The court is voting 6-3 to reinstate a lower court order that had ensured hospitals in Idaho could perform emergency abortions to protect the health of the mother, despite Idaho's strict law allowing abortions only when the life of the mother is in danger. In the copy of the opinion, the court as a whole doesn't explain its decision, saying the appeals are being dismissed as improvidently granted. That means the court is not resolving the core issues in the case. Joining me is Bloomberg News Supreme Court reporter Greg Storr. So, Greg, explain how we obtained a copy of this decision, which isn't necessarily the final ruling, since the court hasn't released it yet.
Yeah, it just briefly appeared on the court's website around the time it was releasing other opinions, and then it was quickly taken down. The court has confirmed that something was inadvertently put online, says it's not a final decision. So we don't know for sure that something here may not change. It is possible that one or more justices wanted to rethink something, but by all appearances, it looks as though the court is going to allow emergency abortions to happen in Idaho.
This is sort of a non-decision. I mean, they're dismissing it as improvidently granted. Explain what that means.
Yeah, that essentially means we shouldn't have taken this case, or in this case, a concurring opinion by Justice Barrett suggested things have changed since we granted it, and so it no longer gives us the opportunity to resolve the issue we thought we were going to resolve. But the other half of this decision, they dismissed the appeals, but they also lifted a stay they had put in place back in January, and this stay blocked a lower court injunction that had said emergency abortions are allowed to happen in Idaho. And so that actually does have some significance, and that is what brought about the sharply worded dissenting opinion.
So, Greg, the court as a whole doesn't explain its decision, and you have this 3-3-3 split. The three liberals in the majority, the three most conservative justices in dissent, and then the three justices sort of in the middle, concurring with the liberals. Are the three liberals the only ones who said that this federal law, EMTALA, requires hospitals to provide abortions that Idaho's law prohibits, and when that's so, Idaho's law is preempted?
Yes, they said that. They were in the majority, but they didn't form the majority because it's only three of them. You're right. Three other justices, the justices in the middle, Barrett, Kavanaugh, and Roberts, didn't directly say how they would rule on that issue. And then the three dissenting justices made pretty clear that they would, if they had a chance, say that this law, EMTALA, does not apply here and Idaho can fully enforce its abortion ban.
What does Alito's dissent stand for?
Well, it stands for the notion that he really wanted to decide this case, and he wanted the court to say that EMTALA doesn't apply in this situation, that EMTALA doesn't tell a state that it has to allow a certain medical procedure, in this case, abortion. But instead, the court backed out of that. Now, one justice we haven't mentioned, Justice Ketanji Brown Jackson, sort of agreed, yeah, I wish we would have decided this case too, but she would have come out the other way. She dissented from the decision to dismiss the case, but would have ruled the other way from Justice Alito.
Yeah, I mean, she said, so to be clear, today's decision is not a victory for pregnant patients in Idaho. While this court dawdles and the country waits, pregnant people experiencing emergency medical conditions remain in a precarious position as their doctors are kept in the dark about what the law requires. Do you think they didn't reach that because they couldn't get 5 votes either way?
It's pretty hard to say why they reached this decision. I mean, it was clear during the arguments that some justices, particularly Justice Barrett, Justice Kavanaugh, were sort of less clear about what was really at stake, what the difference, what it was that Idaho law would ban that federal law would allow. So that seemed to be why they wanted to back out of the case. It is because the court as a whole doesn't give an explanation. It's a little hard to sort of figure out the entirety of what happened.
It really is. The concurrences, the justices in the middle, what did they say had changed to make them dismiss this as improvidently granted?
They said a couple things had changed. One, they said that Idaho law had changed, and there was an Idaho Supreme Court decision. There were some things that the Idaho Solicitor General said in the brief that made them think that maybe they weren't banning as many abortions as perhaps they originally thought. And they also said that the United States, the Biden administration, had clarified that EMTALA doesn't reach quite as far as maybe some of them thought it did originally. Now, I think, both of those assertions, maybe could be disputed, but that's at least the way those three justices saw it.
I remember in the oral arguments, Elena Kagan being very passionate, and in her opinion here, she spends some time talking about how this has affected women who have needed abortions in Idaho.
Yeah, and there was a lot of briefing on that, and people who were, I talked to before the argument, talking about the effect it was having on both patients and doctors. Doctors, in some cases, saying, we need to send you to another state, we need to airlift you to another state because we don't think we can perform that abortion, that needed abortion here without running the risk that we're going to be prosecuted. And also patients who are told, you're not quite at that level yet where your life is at risk. It's only your health that's at risk. So we essentially need to wait until things get worse. And, those are the things that both Justice Kagan and Justice Jackson talked about in their opinions for why it was really urgent that the court do what it did.
So what happens now? This goes back to which court and litigation starts up again?
Yeah, so this will now, presuming this opinion becomes final, and keep in mind it's not actually final, but what would happen would be that it would then go before the Ninth Circuit. There's this preliminary injunction that a district judge has put in place. That's the thing that is allowing emergency abortions right now, and that's on appeal. The Ninth Circuit will decide that. We could well have this coming back to the Supreme Court. We could also see there's another case involving Texas, basically the same issue that could reach the Supreme Court as well. So it's possible that there will be, almost certain there will be another attempt to get the Supreme Court to resolve this issue.
Yeah, and Justice Jackson mentioned that the Fifth Circuit, that case was likely to come before the court, and that's one of the reasons why she said we should resolve this.
Yeah, this is just a temporary order. It is certainly, from an abortion rights standpoint, it is certainly a win. Folks on that side can breathe a bit of a sigh of relief, but I think there's a broad recognition, or there will be, when it's finalized, that the court is not resolving the ultimate issue in their favor.
This is the court's second case this term involving abortion. We had the case involving the abortion pill, mifepristone. And in that case, too, they didn't decide the merits of the case, and it's likely going to come back to the Supreme Court. They issued a procedural ruling saying there was no standing. Here, again, another procedural ruling. But what I noticed today, Greg, is that usually in 6-3 decisions, it's the 6 conservatives versus the 3 liberals. But this opinion, if it's a final opinion, is the third one today where the hardline conservatives are the 3 in dissent.
Yeah, that sort of block of Barrett, Kavanaugh, Roberts, have been, many times like kind of a centrist block, and they can, swing one way or another. Those 3 justices in particular tend to be reluctant to move as quickly as some of the more conservative colleagues, whereas where you're referring to, Alito, Thomas, and Gorsuch are much more willing to issue bold rulings that make a significant change to the law.
Why did the court take this case? Was it a situation where they had to take it?
They were not forced to take it. In fact, it was very unusual the way they did take it. This was in the context of an emergency application. They were being asked to block this lower court decision. Idaho and Republicans in the state were asking them to block this lower court decision, and the Supreme Court said, yes, we'll block the lower court decision, and in addition, we're going to hear arguments in this case without even waiting for the Ninth Circuit. And so now what's going to happen is it kind of goes back to the normal course, which is the Ninth Circuit will hear it first, and then maybe it will come back to the Supreme Court.
And Alito said something like, what's changed since we issued the temporary stay? Now, this is the second time in recent years that an abortion decision has been leaked, and last time it was deliberately leaked to Politico, the Dobbs decision. Yeah. Does this cause a problem for the court?
This is a very different sort of thing. I don't know. We don't know, how the Dobbs decision was leaked. This was more somebody, it seems like they have messed up. So it's a different sort of problem. There have been issues like this in the past, going a little bit further back where things were posted a bit earlier than they were supposed to be posted. So this is perhaps more like those in terms of how it went about. I would assume the court will figure out what happened here and try to take steps to keep it from happening again. But we've seen that, human error happens, and technology being what it is, sometimes information gets out before the court wants it to.
The court never did say what happened with the leak of the Dobbs decision, saying the investigation didn't turn anything up. We'll see if we hear more about this. And tomorrow and Friday, 2 more opinion days to keep you busy, Greg. Thanks so much. That's Bloomberg News Supreme Court reporter Greg Storr. Coming up next on the Bloomberg Law Show, the Supreme Court clears the way for the Biden administration to communicate freely with social media companies in an election year ruling that bolsters the government's ability to seek removal of what officials see as misinformation. I'm June Grasso, and you're listening to Bloomberg. The Supreme Court today tossed out court-imposed restrictions on contacts by the White House and several federal agencies. The decision clears the way for the Biden administration to communicate freely with social media companies in an election year ruling that bolsters the government's ability to seek removal of what officials see as misinformation. In the 6-3 decision, Justice Amy Coney Barrett wrote that the justices didn't need to resolve the First Amendment issues in the case because the challengers here lacked legal standing to press their lawsuit against the federal government. Joining me is Eric Goldman, a professor at Santa Clara University and co-director of the school's High-Tech Law Institute. Eric, tell us about this case brought by 2 Republican-led states and 5 of their residents.
The case is about the government's constant dialogue with Internet services over their content standards. And in particular, the Biden administration was constantly talking with social media services about their content moderation of COVID-related posts and election-related posts. And the plaintiffs alleged that those conversations led to their content being censored, and they sought redress in the courts.
The decision was 6-3 with a change here, the 3 most conservative justices in the minority. What does this decision stand for?
This decision turns ultimately on what I think is best described as a technical or procedural question, but it's actually really important. It turns on whether or not the plaintiffs have the right to access the courthouse at all. And it might sound weird, but plaintiffs don't just automatically get the right to show up in court and have courts hear their cases. They have to show that they have, quote, standing, that they have a problem that the courts are designed to solve, and if they can't show that standing, then the court can't hear the case. And so the majority in this case said that the plaintiffs, alleging that their content had been moderated, lacked standing to complain about it. So they didn't meet the procedural requirements to get into court.
Justice Amy Coney Barrett wrote, "The plaintiffs, without any concrete link between their injuries and the defendant's conduct, ask us to conduct a review of the years-long communications between dozens of federal officials across different agencies with different social media platforms about different topics." Does it tell the government how they can now interact with social media companies? Is there any guidance there at all?
The court didn't get to the substantive question of whether or not the conversations taking place between the government and the Internet services was, in fact, censorial. And I think many people expected the court to address that substantive question. But because the court took the procedural question and resolved it, it dodged the substantive question. We don't actually know where the line's going to be drawn about those government service dialogue.
The court seems to be dodging quite a bit this term, and maybe there'll even be more. I mean, they dodged the main issue about mifepristone by going to standing. So is it a way for them to get a majority without having to address so many controversial issues in one term?
It's definitely a frustrating moment for the parties to not get the answers to their core question and to have the court end the conversation on what might be considered a, quote, technicality. Having said that, standing is a really important doctrine, and it is entirely appropriate for the Supreme Court to address the standing issue and to conclude that standing was lacking. Now, what will likely happen in this case is that the plaintiffs will file a new complaint where they will try to address the standing issue, and ultimately it seems likely that the substantive question that's at issue in this case will come back to the Supreme Court. So they might have dodged the question for today, but they may not dodge it in the future. But even the dodge today still has value because it helps people understand that not everyone gets into the courthouse. You have to put the story together in a way that the law recognizes.
So the dissenters, Justice Samuel Alito, joined by Justices Clarence Thomas and Neil Gorsuch, he dubbed the case one of the most important free speech cases to reach this court in years, and he called the conduct of the officials sued in the case unconstitutional, coercive, and dangerous. What do you make of the dissent? Is this a really important free speech case that the court has ducked?
Well, it depends on how you think about the conversations that take place between the government and the Internet services. If you view those conversations as an attempt of the government to impose an orthodoxy on how we talk to each other online, then you can view all of the government dialogue with services as a massive censorship engine. And that sounds pretty troubling to me. If you view those dialogues as something else, like the fact that governments are constantly encouraging the private sector to think about what they're doing, improve their practices, to consider values that might not be obvious, then those conversations are not menacing at all. In fact, they're really, really important. Certainly when it comes to things like ending the pandemic, anything the government can do to end the pandemic quicker is a win for society. And so that doesn't sound necessarily like censorship. That might very well be the kind of thing we want governments to do. So I think that the real difference between the majority and the dissent was how specific do the plaintiffs need to be? And the dissent's view was all you have to tell me is that the government's leaning on the services, and that sounds good enough to me. And the majority said, no, you actually have to show the government was leaning on the services in this way at this time in a way that hurt you. And so I think that the majority and dissent haven't even gotten to the substantive questions yet in a way where we can see that they actually disagree about those.
And in Justice Alito's dissent, he says that the court is shirking its duty, something he also indicated in the Idaho abortion case.
To me, I think that it's unfair to criticize this opinion as the court not wanting to deal with the substantive issues, because I think standing is so important to the overall well-functioning nature of our court system that we have to respect this procedural hurdle, and if the plaintiffs can't even get over that procedural hurdle, they don't deserve the right to get the substantive answer. So in my sense, I think that's a little bit unfair for Alito to cast some shade on the majority dodging the question, because in a sense, actually, I think they're answering a really important question that we have to answer before we get to other important questions.
So in light of this opinion and the fact that, there's no guidance in here, does this mean that the Biden administration is free to communicate with social media companies to remove misinformation, disinformation prior to the election?
I guess I wouldn't phrase it that way. This particular case involves the Biden administration's conversations with Internet services, but it's not a Biden administration problem. Trump's administration had dialogues with Internet services, and if Trump gets back in office in 2025, that dialogue will resume. It's a government-private sector conversation that's taking place. And that government isn't just the Biden administration. It takes place at the state level, at the local level, takes place from water boards to school districts. All the governments are constantly talking with social media about their particular concerns. So I don't see it as a Biden administration issue. I see it as a government-private sector issue. Now, having said that, we don't get any answers about when the government overreaches those conversations, though we did get some insights from a Supreme Court opinion a month ago, the NRA versus Volo case, where the Supreme Court said there are times at which issuing an instruction about speech coupled with a very clear threat of punishment is unconstitutional. That's censorship. And so we got more substantive answers, I think, a month ago, and that plus the standing issue actually gives the governments a lot to work with.
And this is another case of the Fifth Circuit, that very, very conservative circuit, being reversed. I think it's the fourth case so far this term where the court has reversed the Fifth Circuit. Do you think the justices are sending them a message? They could be taking the place of the Ninth Circuit, which used to be the most reversed circuit.
Yeah, and the Federal Circuit also had a
pretty
rough track record for a while. From my perspective, the Fifth Circuit has essentially seceded from the nation in terms of applying the same set of laws, and they're making up their own law. And I'm heartened to see the Supreme Court push back on that, because so much of the Fifth Circuit opinions are written with an eye towards appealing towards people like Justice Thomas and Alito. It's literally designed to send them the signals to change the law. And so far, the Fifth Circuit's not winning that battle. And I would like to think they would get the message that they're doing it wrong and will improve, but I don't think they plan to.
Yet to be decided are the cases over the Texas and Florida social media laws. Does this case have any implications for those? I mean, does the ruling here point to anything in those cases?
So we're eagerly waiting for the Supreme Court to tell us the answers in the social media censorship cases involving Texas and Florida statutes, which in my mind are even more important than this case in terms of, quote, government censorship. And the current case doesn't answer the questions that need to be answered in those cases, but depending on how the court answers the questions in the Texas and Florida cases, it's possible that the opinions will become unreconcilable. This opinion says that Internet services are free to decide how to handle their content moderation discretion, and it says that many times in multiple ways. Both the majority and the dissent say that. If the Texas and Florida laws are upheld, they strip away the freedom of Internet services to manage content as they see fit. That would be inconsistent with each other. My hope is that the court in the Texas and Florida social media censorship cases will say that Internet services are free to manage content as they see fit, just like the court said in this opinion in a non-binding way, in which case the opinions will be reconcilable with each other. So we'll see.
A good legal conclusion. Thanks so much, Eric. That's Professor Eric Goldman of Santa Clara University Law School and co-director of the school's High-Tech Law Institute. Coming up next on the Bloomberg Law Show, Julian Assange is a free man in Australia. We'll tell you about the plea deal that ended his nearly 15-year legal saga. I'm June Grasso, and you're listening to Bloomberg. Hours after pleading guilty to obtaining and publishing U.S. military secrets, WikiLeaks founder Julian Assange returned home to Australia to the cheers of supporters, ending a nearly 15-year legal saga. That legal fight drew international headlines as he camped out in the Ecuadorian embassy in London for 7 years, getting asylum on the grounds of political persecution while welcoming a parade of celebrity visitors, getting married, and becoming a father of 2. But in 2019, Ecuador revoked his asylum, allowing British police to arrest and lock him up in a London prison, while the U.S. Justice Department sought to extradite him. The criminal case brought by the Justice Department during the Trump administration centers on the receipt and publication of hundreds of thousands of war logs and diplomatic cables that included details of U.S. military wrongdoing in Iraq and Afghanistan. The original charges, 17 related to espionage and 1 to computer misuse, carried a maximum penalty of 175 years in prison. Under the plea agreement, Assange pleaded guilty to 1 felony, and the judge sentenced him to the 5 years he's already spent in prison in the UK. Assange's wife, Stella, said he never should have been charged.
It's an attack on the public's right to know, and it should never have been brought. Julian should never have spent a single day in prison.
To his supporters, Assange is a martyr who's been persecuted for exposing corruption and war crimes. To others, he's an unscrupulous hacker who put lives in danger by publishing sensitive state secrets. Joining me is Adam Hickey, a partner at Mayer Brown. This is a nearly 15-year legal drama. Why do you think this resolution now?
Well, the longer a case like this goes on and the more uncertain extradition becomes and the longer a defendant spends in custody, the balance of factors shifts. And sometimes, as the saying goes, a bird in the hand is better than two in the bush. So I suspect the decision by the British court in May, allowing yet another round of appeals, together with the fact he was already detained for about 5 years and the likely sentence, led U.S. officials to conclude this was a better way to bring finality and certainty to the case and achieve a guilty plea and admission of wrongdoing, which is one of the department's principal priorities in any case.
Yeah, let me ask you about that, because he pleaded guilty, but at the same time he gave this statement to the court that seemed to indicate he didn't think he was guilty. He said, "Working as a journalist, I encouraged my source to provide information that was said to be classified. In order to publish that information, I believe that the First Amendment protected that activity. I believe the First Amendment and the Espionage Act are in contradiction with each other. But I accept that it would be difficult to win such a case, given all these circumstances." So he said he's guilty, but is he saying he's guilty?
Yeah, that's a fair point. I think a lawyer would hear that statement to be a protest, essentially, that this should not have been a crime, but he's not disputing the facts that, in the government's view, make it a crime. And so it's different from asserting a factual innocence, which, if he had done that, the court probably could not have accepted his guilty plea. So put it this way, it was good enough. It was good enough for the government and good enough for the court.
President Joe Biden had said in recent months that he was considering a request from the Australian government to strike a deal to allow Assange to return home. However, the administration distanced itself from the plea. The national security spokesperson said it was an independent decision made by the Department of Justice and there was no White House involvement. Is that believable? I mean, Biden was talking with the Australian Prime Minister.
Yeah, but that doesn't, presidents, and I had the pleasure and honor of serving in the Justice Department under a number of presidents, almost all of whom said something at one point about one of the cases I was handling, but that never filtered down to me in terms of a direction on how we would proceed. Every attorney general I worked for held the line, and I always felt like I was taking direction from them, not the White House. So here, whatever the president said to the press, I believe the decision was made by the department on its own.
Does the department take into account that, he has said things like he thought that the U.S. government was trying to assassinate him, that after some time he's going to go on talk shows and write a book, et cetera, proclaiming his innocence and bad-mouthing the U.S.?
I don't think the Department of Justice cares very much about that. I think there would be concern if there were belief that he still had classified information in his possession or within reach, and I suspect they would think about that in reaching any resolution. But whether he wants to call the department names, those aren't sticks and stones. I don't think they'll care very much about that, and I don't tend to think they take it personally when a defendant has a gripe for being convicted of a crime.
So the U.S., seemed to go out of their way to accommodate him. He didn't want to appear on U.S. soil, so they had the proceedings take place in this federal court based in Saipan. Why take such steps? Why not have him come to the continental U.S. and plead guilty?
Yeah, I think it goes back to your first question about why resolve the case now and why do it in this way. I think he had some leverage because as long as he's willing to sit in a UK prison or jail, rather, fighting the extradition, and as long as it looks like that's going to draw the process out, he has some leverage over the Justice Department, which wants to get a resolution. And so if the price of that resolution is a guilty plea in a territory as opposed to the continental U.S., I think you could find lawyers in the department who would just accept that as a compromise. What matters is it was a plea in federal district court, wherever that court may be.
So finally, he's barred from returning to the U.S. without permission. And his family says he'll be seeking a U.S. presidential pardon, arguing the deal sets a dangerous precedent for journalists. Do you see Joe Biden or Donald Trump granting him a presidential pardon?
I think it's hard if you look at the facts. You recall that the information attributed to WikiLeaks was put online without any kind of filtering or editorial curation, unlike what you'd see a major news outlet do. And that as a consequence of that, at least according to press reports, sources or others died or were at least put in physical danger. So I would be surprised if you saw an American president exercise clemency that way. But, American politics can be surprising. So I guess we'll see. I mean, his supporters really look at this as a slippery slope and argue you can't make a meaningful distinction between him and a journalist. And I think you can be more critical and say, in fact, there are distinctions, and one of the most important ones, which is, many journalists that expose classified programs do so after listening to the government make arguments about how best to protect human lives or other important equities. And that, if you're an organization that believes in transparency above everything else, that distinguishes you from journalism, which is not just about promoting the transparency of information.
I am completely sure that we are going to be hearing a lot from Julian Assange in the future. Thanks for being on the show, Adam. That's Adam Hickey, a partner at Mayer Brown. In other legal news today, Homeland Security Secretary Alejandro Mayorkas says the actions taken by President Biden to limit the amount of asylum seekers coming to the southern border are already garnering results. According to Mayorkas, border encounters have declined by about 40% at the southern border, and more than 24,000 people have been returned to their home countries.
Across the entire southern border, Border Patrol encounters have dropped by over 40%. We are removing more non-citizens without a legal basis to stay here.
In Arizona today, Mayorkas also stressed the need for Congress to approve funding for more resources, especially at U.S. ports of entry, to help those who try to apply for asylum in advance via an app.
The number of appointments that are permitted through CBP, approximately 1,400 to 1,500 a day, are based on the capacity of our ports of entry. They are antiquated ports of entry that are also in need of funding to modernize them.
Overall, border encounters have been on the decline since February. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.